For the very first time in the electoral bonds case, today we heard the views of corporate India. Never before today have they appeared or argued in the Supreme Court on their names being disclosed as political donors. So what do they want? Let's take a look. India's leading industry bodies, the CII, FICCI and ASSOCHAM today appeared before the top court and for the first time openly batted against disclosure of alphanumeric serial numbers of electoral bonds. They argued that they are comfortable with two separate lists of corporate donors and recipient parties, but they strongly oppose releasing serial number as that would link the two sets of information and disclose specific donations by corporates to a particular political party. So why the concern? Well, there are a number of them. The biggest concern, however, for India Inc. appears to be that of political vengeance and retribution. And they are not mincing words. The plea by ASSOCHAM, for instance, very clearly says that due to anonymity, many companies had picked these bonds due to fear of consequences from political opponents. They argued that preserving privacy was critical in guarding against any adversity by parties to whom contributions were not made. The plea argues that information linking one company to a party can be hugely damaging. Concern number two, retrospectivity. Industry bodies have argued that bond scheme allowed for anonymity. They argued that the Supreme Court order has retrospectively applied a higher standard of disclosure. This, India Inc. argues, is against the principle of certainty and predictability. They claim that this undermines the rule of law. Concern number three, no hearing. The industry bodies claimed before the top court that not once were they heard. They claimed that the Supreme Court had passed orders without hearing concerns of corporate donors. Their applications have argued that the principles of fair hearing and natural justice should be respected. And finally, concern number four, statutory rights. Corporates have sought to argue that the law gave them the assurance of confidentiality. They have argued that there was a legitimate expectation of confidentiality, and this formed the basis of their decision to buy these bonds. This confidentiality, as per the industry bodies, was a statutory right. The Supreme Court, however, was not impressed with these arguments. The court observed that it had passed the interim orders way back in April of 2019 and that the interim orders had put to notice all stakeholders about the uncertainty over legality of electoral bonds. The whole world knew, the Supreme Court observed today, and that corporates had looked to join this hearing only after the Supreme Court judgment. So for now, clear directions for SBI to release the serial number of electoral bonds.